We are living in a rapidly changing environment with policy in many areas of our business changing faster than we can keep up. We know how critical it is to equip our teams to respond and adapt to these changes successfully, whether it be as a result of new technology, changes in the workforce and economy, and sometimes at a moment's notice, climate-related emergencies. Change is not new and has always impacted our businesses. And through building clear operational procedures and processes, we strengthen our resilience that better prepare us to lead our teams through any upcoming challenge. Since pre-consultation began on Bill 41 in 2022, we've been sharing information on the upcoming developments to keep you appraised on the changes and impacts of this new legislation. A bill that speaks to the legal duty for employers and workers to cooperate in timely and safe return to work. But what does this mean for workers and employers, and how do we adapt our programs to meet the intention of the legislation successfully? Well, today, we're here to find out. We have the opportunity to hear from return to and/or return to work. Beginning with you, Teresa.
Good morning. My name is Teresa Chung, and I'm a client service manager with WorkSafe BC in the Return to Work Services Consultation and Education Department. In my primary role, I work with employers in their return to work and disability management programs. My background is in vocational rehabilitation and law.
Thank you, Teresa. Allie, welcome.
Thank you so much for having me. I love that we're having an all-female panel this morning. My name is Alejandra, and I also go by Allie, and sometimes I get called Ale once in a while. I am a lawyer here at Kane Shannon Weiler, practicing labor and employment with a focus on WorkSafe claims and other employment disputes. I assist employers in all kinds of employment-related issues, from drafting contracts to helping clients terminate an employee or assessing very difficult employment situations that sometimes yield to involving other WorkSafe claims. I also help employers and also employees with WorkSafe claim management, and that applies from board claim management to WCAT appeals and handling everything in between. I also help with assessments and sometimes penalties that employers receive. And I'm really happy to be here today. If you have further questions that we don't answer, you can always contact me via email as well.
Thank you, Allie. Thank you for joining us. And Amanda, thank you.
Hi, Lisa. So thank you for inviting us to be a part of this panel. It's super exciting, new policy changes. I started in disability management in about 2005, 2006. So I've worked in all aspects of performing that role administratively, return to work, medical support, but most recently, I'm the current technical claims specialist here at TextMed. We are an employer representative. And I do everything from dealing with very complex matters to helping with, more serious injuries and return to work coordination, protest, appeals, concerns, all of that kind of thing. So very happy to be here today.
Thank you for joining us. Okay, so moving into a bit of the background of this legislation, Teresa, can you share with the audience here today, what are the primary goals and intended outcomes for the new legislation?
Thank you, Lisa. I'd be happy to. The role of Bill 41 is to provide a legal duty for workers and employers to cooperate in the workers' early and safe return to work. The purpose of the bill, the intended outcomes of the bill is that cooperation and fostering communication. At WorkSafe BC, what we tend to see is employers and workers playing the waiting game, where they are waiting for a decision from WorkSafe BC. They're waiting for something concrete. They're waiting for some type of communication from us before even beginning to engage in communication or conversations on returning to work. Statistics do show that the longer it takes for a person to return to work, the more likely they are not going to do so. So by removing that wait for WorkSafe BC to contact, communicate, make a decision, but to start those conversations early, to start cooperating early, to have communication early, it improves the workers' opportunity and chances to come back to work, to be restored at work, and it also it adds that duty for the worker and the employer to cooperate together in this process.
Thank you. So really opening up that channel of communication is a critical step, right?
Absolutely.
Moving forward with a safe return. Excellent. Ally, your thoughts on how does the new legislation impact employer obligations and responsibility, and how does this legislation affect injured workers?
Employer and employee responsibilities are definitely heightened since Bill 41, and I want to start by talking about what it means for employers and what it also means for employees. So we have the duty to cooperate and the duty to maintain employment, which are terms that we have probably heard so far, and those carry great responsibilities for employers. So employers have the duty to contact the worker as soon as they are able to find out what is up with the worker's injury. They don't have the ability to request detailed information about their diagnosis, but they can ask, what is your medical standing right now? When are you able to return to work? What are some possible limitations and restrictions? They can ask, what are some details that you can give us so that we know when we could potentially start planning your return to work. And this can get a little bit challenging for employees who were bullied and harassed at work and may have a psychological injury claim. So WorkSafe takes that into account, but the duty to cooperate encourages employers and employee to exchange information, which is sort of a shift from how WorkSafe operated before, where WorkSafe was the heart of the communication hub between the parties. Now that onus is placed on the employer and the employee to streamline that communication, and WorkSafe is always there to mediate and coordinate between the parties. But the reason why this is implemented is to ensure that the employer has a better idea of when the employee could come back to work and what potential position they could offer that employee. And before, WorkSafe was the party who made the decision. The employee is ready, willing, and able to go back to work. And now that communication is just expected between the parties instead of WorkSafe mediating that resolution. For employers, there's also the duty to maintain employment. And this is triggered when an injured worker becomes fit to return to some form of work within 2 years from the date of injury. If the worker can carry out essential duties of their pre-injury work, the employer has the responsibility to offer them the pre-injury work to the worker. But they can also offer alternate work of a kind at wages that are comparable to what they were earning before, to ensure that they can restore their earnings. If the worker is fit to work, but they cannot carry out the essential duties of their pre-injury job, which essentially means they can go back to work in some capacity, but they cannot do their pre-injury job, the employer must offer the worker the first suitable work that becomes available. And there's also the responsibility for employers to think about accommodating the worker, especially when we have an employee who cannot return to their pre-injury position. And accommodation is something that WorkSafe previously did discuss with employers. As you know, with WorkSafe claims, WorkSafe accepts limitations and restrictions for the worker, and they always take those restrictions and limitations for the worker and ask them, do you have a job that complies with these limitations and restrictions? And we saw that very often through vocational rehabilitation. But now that is sort of moved along earlier in the claim to situations where an employee can engage in some work, but not necessarily return to their pre-injury job. And what does accommodation requirements look like for employer? Accommodation is required to the point of undue hardship. And this is the point at which it is too difficult, unsafe, or expensive to remove barriers so that the injured workers can return to work. And accommodation does not need to be the worker's preferred accommodation as long as it is reasonable. So as you can see, we can expect some communication between the employee and the employer about what is adequate communication. And I think both parties are going to be heavily relying on WorkSafe to determine what is appropriate, because it's not the worker who determines what accommodation is required. They can certainly suggest it, but it is based on what are the circumstances and what's reasonable for both parties to do. So these are some of the responsibilities that are now on employers that perhaps were not there before, or were not as heightened, because, employers were involved through vocational rehabilitation or selective light duty work, but now we see this engagement throughout the length of the claim. Now let's talk about what are the responsibilities for injured workers. They also have a duty to cooperate. So what that means is that when an employer asks them questions about what is their current standing, when they could potentially return to work, whether they're being offered a job, the employee has to engage with that conversation, and failing to do so may result in their wage loss benefits being cut or suspended from the date of when they stopped cooperating, or from the date when WorkSafe determined that the employer offered them a reasonable job. Now, when the parties disagree about a potential return to work outcome, it's important to keep in mind that WorkSafe may try first to mediate the dispute between the parties, and if the dispute cannot be resolved, they may issue a decision that either party may appeal to the review division. So those are the main responsibilities for both the employee and the employer.
Can you talk through the key provisions of the legislation that employers need to understand when bringing employees back to the workplace?
Yeah, the Workers' Compensation Act has new provisions that discuss what are the duty to cooperate and the duty to maintain employed, and I'm going to list what all of those are. But I think it's also really valuable to direct you to the Rehabilitation Services and Claims Manual, which sort of makes this information easier to digest. So you can always check these applicable sections there. But with respect to the Workers' Compensation Act, Section 154.1 applies to allowed claims where there is an impact on the worker's income due to a workplace injury, mental disorder, and occupational disease. So what this means is that the duty to cooperate is triggered when a worker is suffering a loss of income because of the injury and their inability to work. Section 154.2 discusses the duty to cooperate, and this requires workers and employers to cooperate with each other in WorkSafe BC. And again, like I mentioned, there are consequences for failure to cooperate. The employee may experience a loss of benefits, and the employer may also be issued a penalty for not cooperating with the employee. And both of these parties can bring a complaint to the case manager's attention for the other party's lack of cooperation. Section 154.3 discusses the duty to maintain employment, which, like I mentioned, requires an employer to maintain the workers employed, offer alternate employment, and also consider accommodation for that employee. And Section 154.4 sets out how the new obligations interact with collective agreements for union workers, and specifically discusses how does return to work impact unionized workers.
Excellent. A wealth of information. And I will say to our viewers, any resources or related links will be incorporated certainly at the end when this is a recorded session, and distributed to all of those that are registered. So just a quick addition from that. Amanda, let's talk about proactive steps. Can you suggest some proactive steps that employers can take to ensure compliance with this evolving legal requirement?
Yeah, so I think the first thing is employers, some employers right now are in a little bit of a panic. To be fair, it's a big policy change. We don't normally see such a large revision of policy. So I think it's important to keep in mind that these are expectations and really best practices that we've all been dealing with for some time in practice. A lot of these things are things that you're already doing. So it's more just that it's been developed into a more formal requirement, which is kind of what Ali touched on. Some things were previously thought of to be the nice thing to do or the generous thing to do or maybe optional. And it's really just WCB bringing all of this stuff in line with existing legislation. So I think the first thing everybody needs to do is just kind of take a breath and remember that, you know, we've been dealing with this for the past couple of years, and it's not a huge change. It's just the formalization of that. So some best steps that employers can take. I mean, the first one is not to wait for an injury to happen to start thinking about these things. If you leave everything until you have that incident or a serious injury or an accommodation request to come in, it can quickly be overwhelming. There's a lot to figure out. You're trying to wrap your head around policy and what can we do here? What do we need to do? So I think the best thing about all these conversations right now is it's a trigger for employers to really sit down and think about their existing programs, what processes and procedures you have in place. And now's the time if you need to revise those things, or if you don't have a modified duties program, this is the biggest cue to sit down and start having those conversations. So some of the things employers want to make sure are in place, clear reporting procedures. That's number one. Make sure your workers and your employers, you know, employers tend to make sure supervisors are aware you have to report this injury, but it's important to have those, you know, toolbox talks, lunchtime break meetings to make sure that employees, new hires are up to speed on when they need to inform of an injury. If an injury happens, who are they going to report that to? So that's going to be the first thing. Another thing to take that a little bit further is just the education of supervisors, staff, HR, anybody who's involved in that process. Again, in the past, this was seen as something that, you know, it was great to do. It was a best practice to do it. You know, if you were a good employer, you would do it. Now with these requirements, it really is a requirement. It's no longer optional. So making sure your staff and everybody who's involved in that process is aware of the importance and why that's important. The other outside legislation that also makes those things an obligation is really important and kind of gets everybody on the same page that you need to be supportive with your workers and whatnot. So that's a good step. The other thing is your modified duties program. So most of us will have a modified duties program already in place, but as I mentioned in the beginning, this is a really great trigger to really sit down and take a look at those modified duties, make sure you've identified them. And, you know, injuries and situations are super unique, so you're not going to have a perfect fit for every injury, but it's a great time to take a look around and think, hey, what could we do? These are the most common kinds of injuries we have. Gather some data and start having those conversations about your flexibility and identifying some modified duties so that when an injury does happen, you're prepared.
That's excellent. A wealth of information, you know, ensuring that you have a comprehensive return to work program in place. It's well communicated at all levels of the organization. You have an effective modified work program so that you are prepared in advance for in the event that you do have a team member that gets injured. You have all of these in place and everybody knows about them. So excellent. Thank you. As a Health and Safety Association, we're here to help as well businesses across the province with health and safety compliance and other needs, and inviting you to reach out to us for advice and support as these changes get in place, and that we connect you with the right individuals. So Teresa, coming back to you, I know that your team as well at WorkSafe BC offers support specifically around return to work. Can you talk about how you're supporting organizations around these changes?
Absolutely. One of the primary things that we did to help to support organizations and employers was just to get an informational webinar out there before Bill 41 came in effect on January 1st, 2024. So on our website, worksafebc.com, you have access to that recorded webinar, and it goes through the duty to cooperate, the duty to maintain employment. There are frequently asked questions that we received, and also questions that happened at that particular webinar. So that has been really helpful for people. Also, in return to work consultation and education services, because we work with employers and their disability management programs, we offer return to work coordinator courses where we work with managers and we work with supervisors and whoever your return to work coordinator is in helping you to get people back to work, keep people connected to work, and stay compliant with Bill 41. We give the education that's there. We talk about suitable work, what it is, and how to offer it. We also talk about that communication piece. One of the frequently asked questions that we get at WorkSafe BC is, wow, how do I document Bill 41? How do I let you know that I've been trying to call them? How do I tell you, And so we talk about the portal, we talk about communication with WorkSafe BC, we talk about documenting all of these conversations from the beginning, from your initial reports that you were submitting to us, and also that ongoing communication piece. And also at Return to Work CES, we have a telephone line and an email address where you can submit questions, whether it's related to Bill 41, whether it's related to your injury management process, in which if you have specific questions and it just feels like we didn't address it because your situation is special or different or not the common question, you can submit it to us, and within 48 hours, you'll have an answer to your telephone call or an answer to your email. The line is monitored heavily, and actually this is something that we've had prior to Bill 41, where we always provided this type of information and support to workers. You can always make requests for further education. You can always make those types of requests, and we will provide it. Now, when Bill 41 came into effect, it was for support and communication between the worker and employer. Well, there's also a duty there for WorkSafe BC. So what we also have provided, we have hired initial staff, we have put additional supports in place to make sure that there are return to work planners available to help with return to work plans, that there are return to work specialists available who can help with identifying suitable work. We have so much in place to help make this successful for employers. And if you reach out to us, we can make sure that you are given the proper support that you need to help you to remain compliant. What we find, most of our employers across BC are compliant. They want to be compliant. They want to support their workers. And this bill, even though it adds a legal duty, we find that most employers have been doing all of these things from the beginning. So we are offering to support, to help you to continue to support your workers, to help you to continue to keep them connected to work and also maintain their employment. So you can reach out to us, you can contact us. And also if you go to our website, you will see a lot of resources listed. I left some behind today as well to be provided to you for any additional questions that you may have to continue to support you through this.
Thank you, Teresa. And we will certainly include all of those resources, including the number, as part of the package that is circulated once this webinar recording is prepared. So thank you for providing the detailed list of the wealth of support, which is critical with this change.
Mm-hmm.
So looking at the other area of oversight and responsibility, how will WorkSafe BC monitor and enforce compliance among employers and organizations? What is the vision around that?
Well, the vision around that is, again, we feel at WorkSafe BC, and just in looking at our claims and our relationships with employers, that most employers are making the effort to be compliant, making the effort to keep people connected at work, and making the effort to comply with Bill 41 even before it became in existence. Bill 41 provided the legal duty, but for most employers, that duty was already there. So when we find someone who is not being compliant, our first response is one of connection and of support. We're going to reach out to those employers and find out exactly what's going on, because sometimes it's hard to see where you fit in the legislation. It's hard to see where you fit with return to work. Your situation may feel different compared to what everyone else is dealing with. So we want to reach out and make sure that you do understand what your responsibilities are under the bill, what your duty is. We want to look at your unique circumstances and see if we can consult with you and help you to find answers. We also will connect you to people who can help you with some of those return to work plans, or even identifying what suitable work is at your particular employer. So our first step is to make sure that you're connected and to make sure that you have an understanding. In rare circumstances, it is there. There is a duty under this new law that consequences and penalties can be applied. And in rare circumstances, that will indeed happen if someone remains uncompliant, but they would have to remain non-compliant in order for that to happen.
So that's excellent to hear. Consultation is the first step in really reinforcing understanding of the legislation and how you can be successful, right? So excellent to hear. Amanda, how can employers handle accommodation requests from employees who may have health concerns or other reasons for needing special arrangements under this new legislation? Can you talk through those circumstances for the audience?
Absolutely. And I'm sure Ali will touch on this too from a more legal background, but some things that employers should be looking for when they're receiving an accommodation request in general is that it's medically supported and documented. So employers aren't always privy to, diagnosis or that detailed information, but a worker does need to supply, or in the case of a claim, the board needs to supply enough information that you can make an educated decision and assessment on if you're able to accommodate that and what that's going to look like, right? So that would be the first step, is to get the details of that accommodation request. Another good question is a temporary accommodation request? Is it permanent? Just enough information that you can make an accurate assessment. And, these decisions usually aren't made overnight, and it's going to take some investigation on the employer's behalf and some work to make sure that you're reviewing that thoroughly. Another thing to consider is to keep communication open. And I think that's going to be something that all three of us are recommending from all aspects. In regards to claims, in regards to accommodations, this is still your worker. So, sometimes it's not always going to be a preferred accommodation, but ideally it's something that the worker is also agreeable to. And keeping that communication open is a great way to kind of identify maybe some of the barriers, some of the concerns they're having, if there's issues in the work environment, if they're not feeling supported, liaising with that worker and making sure that you're really understanding where they're coming from, if it's a claim, as well, what the case manager's stance or vocational rehab specialist stance is on what's going on as well. Another thing you can do is keep in mind that it's not always going to be a preferred activity. So, sometimes workers will say, well, I have this problem and I'm thinking I should take X job. In a perfect world, maybe that can happen, but sometimes it's going to take a little bit more thought. You might have to create a new position. It might be a position that neither you or the worker has ever considered. So you really want to think outside the box there, keep your mind open. Like I said, talk to the worker, consider all the different factors. Another thing is that employers need to keep in mind that it has to be meaningful and safe. So we have seen sometimes where employers have came back and said, it's a requirement I accommodate somebody. I'm just going to, stick them in a desk in this corner and we'll call that done. But that's not adequate. We have to make sure that it's beneficial to the business, it's meaningful to the worker. If it is an accommodation that isn't their pre-injury position, that it's something comparable to that. So those are all some really great things for employers to keep in mind when they're considering those requests.
Thanks, Amanda. And Ali, can you add to, with your wealth of expertise, through accommodations, I would expect that you have worked through for many organizations. Can you provide some additional insight into some examples on what employers need to consider when we look at accommodation, and where you maybe can provide some successful outcomes from what you've experienced?
I think it's important to keep in mind that when it comes to accommodation, employers have responsibilities under the WorkSafe system, but they also have accommodation requirements if a worker is protected under the Human Rights Code. So when an employer is approached with an accommodation request, I think it's really important to understand what is the condition or the situation giving rise to the accommodation, because if it's with respect to an injury that's unrelated to WorkSafe, but is still a permanent condition or a disability that the worker suffered from, you may still have accommodation requirements under the Human Rights Code, which may also trigger accommodation duties to the point of undue hardship. So just because the accommodation that the worker is requested may not be related to their WorkSafe claim does not mean that you're off the hook. So it's really important to understand why is the worker seeking accommodation? What are the conditions that lead to the accommodation? And what also are the accommodations, and how is the worker supporting that accommodation request? Because as Amanda and I mentioned earlier, it's not up to the worker to decide what is the appropriate accommodation that's required. What are healthcare practitioners saying about the accommodation? And is that accommodation reasonable and feasible for the employer to implement? I think, we are getting lots of questions about human rights accommodation and WorkSafe accommodation and how those two things come together. And there are responsibilities under both systems. So I think it's really important for employers to familiarize themselves with the human rights code requirements in addition to the WorkSafe requirements, so that you're not complying with one and breaching the other, and so that you can mitigate any potential consequences there. I think when it also comes to accommodation requests, if you are offering a worker a position, it's really important to communicate that clearly to the worker. And it's best to do that in writing. There's lots of issues, especially in the past when WorkSafe dealt with light duty selective employment. And this was often provided to employees who were not yet able to return to their pre-injury job, but they were able to engage in some kind of work. And there were tons of appeals where the employer did not provide a clear job offer to the employee. And the reason why a clear job offer is incredibly important is because it lists what is the job, what are the job duties that are required, to see if it's feasible for that employee to physically perform those activities. So this is something where I think employers would benefit from in having in writing rather than verbal conversations, where it may just come down to credibility issues. Who do we believe here? And also make it very clear to the worker when they were offered that job, because if they're offered a position that they're expected to take and that WorkSafe finds that is reasonable, WorkSafe may discontinue their benefits from the date of that offer. And if you have that in writing, it's going to be a lot easier to follow.
Are there different processes for temporary versus permanent accommodation? Allie?
Yeah, it really comes down to what does the worker reasonably need in the circumstances. So if the worker cannot yet return to their full duties and they're looking for temporary accommodation, usually a healthcare provider advises the employee what is the length of accommodation. But I think the realities of employees is that the nature of their disability may be changing, and how they get better with treatment may also be changing. So it's also an ongoing conversation with the employee about how is the condition resolving? Is it improving? Is it getting worse? What makes it aggravated? So it may not be a clear answer, this is temporary or this is permanent, but it may be, this is how we're starting, and we're going to check back in 6 months after the pain management clinic determines, what is the most appropriate accommodation going forward. So I would say that that really ties into the duty to cooperate, with ongoing communication between the employee and the employer about what duties can they do, what may be some of the limitations and restrictions, and what type of return to work can they engage in.
Thank you. Excellent information. Looking at now moving into, preparation to support employers, from the vast differences from this legislation in terms of individuals suffering different types of injuries. What have you experienced, Teresa, thus far on some of the common questions or concerns you've heard from employers on this bill, and recognizing, as we've just talked about, the complexity at times for the types of injuries and the return to work?
That is really a difficult question to ask, or answer. And that's because I feel that most employers that we're running across, they've heard of Bill 41, they've done their research, they've attended some webinars. So they have a basic understanding of the duty to cooperate and the duty to maintain employment. What we're finding with a lot of our frequently asked questions is that we're getting into the specifics of how it applies to that particular employer. So we get some of the questions that are dealing with their specific issues. Now, initially, when Bill 41 first came out and it was really getting popular and picking up steam that this is happening January 1st, we got questions around, do I qualify under, how does this relate to me? And so we had to explain that the duty to cooperate is something that all workers, all employers across BC have a duty to cooperate. But for the duty to maintain employment, there is a provision there that if you're an employer with 20 or more workers, and that worker had to be employed with you for 12 consistent months in order for that duty to maintain employment to be triggered. So those were the initial questions is, which one, so am I exempt from both? You're not exempt from both. You do have a duty to cooperate, but the duty to maintain employment may or may not apply to you. So those were the initial questions that we began to see, was whether or not those specific duties did apply. And then as we began to go on, it was like, well, wait, I have temporary workers. How does that apply to me? We have union collective bargaining that outlines a whole different set of rules. How does that apply? And so we have within that webinar that we put out on this November 16th is so good because there's so many different employers attended it. And so the frequently asked questions that came from that have been tremendously helpful for a lot of employers to see how they fit in, but then also the phone line and the email address that we provided also provide information on how it is specific and unique to each person. There are definitions, suitable work that people are beginning to hear that we often use modified work in the past. What is suitable work? It's meaningful work, and it's meaningful work that an employee can perform safely. And also, what happens if I don't have suitable work? What happens if I can't provide those opportunities? Those are the questions that we're getting. And I hope that we have the opportunity to answer some of those questions for you today, because, we have, with those particular questions, we do have the answers for them. And we'd like to proceed and help with those specifically.
Thank you. And we will, just a couple questions left, and we will be opening it up to the audience. So start thinking about your question to the participants, because we certainly have built this webinar to be able to do just that. So Ali, I just wanted to allow you to as well contemplate over the last year. What are some of the concerns that you're hearing that you've addressed from employers around this new bill?
Yeah, one issue that has come up is, how does the duty of employment apply to claim reopenings? So as you know, a worker may reopen a claim if they're receiving surgery for a condition that WorkSafe accepted as permanent. They may have a period of disability where they may be interested in getting wage loss benefits while they're recuperating. And this may be, years after the claim has passed. How does the duty to maintain employment apply to the worker? Does the employer have an obligation to re-employ that worker in either the same position or a similar position? And, the answer to that is that the claims are, the duty to maintain employment runs for 2 years from the initial date of injury. So if a claim has reopened, the date of reopening does not trigger the duty to maintain employment once more. Other questions that we are getting from employers and from employees is, how long does the duty to maintain employment, apply after you have, re-employed that worker? And under the previous system, an employer may have offered the worker a return to work plan, so they were denied vocational rehabilitation for that reason. And if the employment relationship broke within 3 months, that worker was able to then appeal that decision and say, look, I do need vocational rehabilitation because the employer no longer has this job offered for me. And now a benefit to the employees that has been extended now for 6 months. So they have more time to see how does this return to work option with the employer work out for them. And if that relationship breaks out, they have a little bit more time to bring that to the attention to WorkSafe. workers do have 3 months from the date of termination to complain to WorkSafe and, file perhaps an adjudication request that WorkSafe issue a decision on whether the employer failed to maintain employment, but WorkSafe may extend that timeline based on the particular circumstances of the case. So we're getting lots of questions, I think, as Teresa mentioned, that are very fact dependent on how the policy applies to those each particular circumstances. And we're also seeing lots of gray areas. So for example, something that Teresa mentioned is, the policy that may apply is when a worker has been employed for 12 consecutive months. So something that we look at is, if that person went on parental leave, for example, do they still qualify? And the answer to that is yes. If, it's still in keeping with the normal course of employment, you're not expected to work for 12 months nonstop. They look at the circumstances. And if you went on medical leave, maternity leave, you're still deemed an employee during that period, which adopts similar concepts under the Employment Standards Act that deems your employment continuous during those leaves. So we're getting lots of questions about, that 12-month mark, the specific leaves. Does this mean that I'm still protected or am I not? And the answer is it depends on the circumstances.
Wow, very helpful information. Thank you. And then the final question before we open it up to the audience is, Amanda, can you share some examples of best practices or some successful case studies in preparing for changes in the return to work legislation? Oh, sorry, we can't hear you. Your audio.
Sorry, I'm going to share some examples of best practices that we're advising right now. I think successful case studies will see more as things progress in practice and we see how these new law and policies are applied, how employers are really taking this advice and implementing that into their own return to work programs. So first thing, and some of these are going to be a little repetitive, but they're important. Don't wait for the injury to happen. Don't wait for an accommodation request to come in. I can't stress it enough that you're in a much better position when you're not in the heat of the moment, when you don't have, WCB calling, the worker calling, everybody getting heated or upset because things aren't happening quick enough. Now's the time to really sit down and review your program. So make sure you have your policies in place, that you have adequate forms to support those policies and procedures. Let this be the trigger to kind of take a step back and review that program or implement a program if you don't have one. Another one, involve the worker as much as possible. Again, and that's not just with it's great if you're involving the worker when you're looking at an accommodation, like a permanent accommodation, but even when it's a temporary accommodation, it's a temporary disability. If you can involve the worker in that process and not just when it gets to the point of accommodation, but immediately after the injury, reach out to your workers, connect with them, see how they're feeling, how they're doing, identify any maybe concerns, maybe any issues that you were unaware of. And that's a great way to kind of frame everything moving forward. So when you get to the point where you're looking at accommodations or something, you already have that line of communication open and everybody's on the same page about what the expectations are. Speaking of communication, not just the worker, employers have an obligation under this new policy to make sure that they're communicating with WCB too, and that's important. So, you can be talking to the worker as much as possible, but you got to make sure WCB is informed. If you employ a return to work coordinator and you're involved in some of that medical and assisting in those things, involving the treatment providers. A lot of doctors, a lot of physiotherapists are more than happy to provide limitations or clarification. Maybe there's a position or suitable work that's come up and you're both just not sure 100% that it's safe for them to do. So keeping those lines of communication open can provide a lot of clarity as to what's going on in a case. Another one, be flexible. So, we tend to do a modified duties program and identify modified duties and we're like, we have A, Y, A, B, C, D available. Injuries are unique, circumstances are unique, every industry, every employer is unique, so it's not a one size fits all question. So it's great if you can, before the injury occurs, identify some modified duties that are available for maybe the most open injuries that you experience, But when that injury happens, you really got to be flexible and take into consideration. A really good example is that you might offer somebody suitable work that's at a different time of day. And for one person, that might be totally fine. Another person might be a single parent. Maybe they have outside work obligations. So you really have to be flexible and take into consideration the particulars of each case and make sure you're considering any potential barriers. On that note, also a great time to review your HR policies. So I know we tend to fixate on WCB, but if you have a union or a bargaining agreement, if you have existing HR policies, all of those things, now is a time to make sure that they facilitate your ability to meet your obligations under these new law and policy duties. So, if you have old HR policies that are super rigid, that are going to make it really difficult to move your worker from one department to another, now's a great time to maybe sit down with the higher ups and have a discussion about how you can make that a little more flexible, why it's important. Again, the education on what your obligations there are. Further, encouraging a supportive and inclusive work environment. And I mean, that benefits everybody, pre-injury to accommodations, right? When your workers are happy, when they feel comfortable, when they feel supported, and they're not worried about being excluded or any of those things, it's always going to make managing these things better, right? It's a stressful time when it happens. So anything you can do as an employer to encourage coworkers to be supportive, it's quite common on claims where workers go, my coworkers look at me strangely because I have limitations. So things that you can do to address that from an employer are only going to benefit you as you're managing claims and accommodations requests. And the final one, which kind of backs up what Ali said, is document. You want to document everything. So, it's great if you're having conversations or staff room meetings about possible accommodations. Maybe you have a phone conversation with the worker, and it's not to say those things shouldn't take place because they're important, but you should be following up those things with documentation. So, when issues do arise, and unfortunately, sometimes conflicts do arise, or another big concern we hear from employers is, I have to do layoffs, or we had existing HR issues with this worker, and now I feel like I can't address it because of the claim. The key to all of those things is that you need to document those things, and not just when an injury happens, but in general, make sure you're following your HR procedures, that you're documenting any issues that have came up previously. So if and when in the unfortunate case where there is a conflict, maybe there's a debate about the accommodation you offered, if it was suitable, if it was, available to start right away or not, that you have that documentation there, because the onus, and this is one of the things I didn't touch on earlier, is that you have a duty. So you have to prove that, and to the point of hardship, which is what Ali, touched on. And it's very hard to have that in a verbal conversation to say, oh, we did everything we could. It's much easier when there's a paper trail saying, look, we've done everything right from step A to step Z. We have explored all the available accommodations. We've considered, outside of her position or his position, work in other departments, or maybe even financially, if you're claiming financial hardship. The onus of proof for those things is on the employer, not the worker. So it's never a bad idea to have those things documented so that you can show, so that there's no confusion, and just for clarity for everybody involved, that that's what the expectation is. And then to close, again, I think everybody just needs to remember that a lot of these new obligations are really just formalizing things that we were already doing on claims. We were already being asked to do on claims. Suitable work, like Teresa mentioned, very similar to modified work. So it's scary, it's new, it's changes, but these are all things that, have been going on for quite some time. And it's really just shoring that up and bringing that legislation in line with other things, and making sure that there's real penalties for those people who aren't playing ball.
Thank you, Amanda. A wealth of tips, and thank you for that. And wonderful discussion so far. But let's take the time now to move on to some of the questions coming from our audience. So looking at the first question to you, Teresa, and it really speaks to relocation. When a company can offer suitable duties for a worker that declines to relocate, what is the perspective of WorkSafe BC in those circumstances?
Well, again, that's going to be a dependent situation on how the person came into the position and where the person has their most reasonable contacts. Will a person be requested to move? The offer should be made. If there is a position available that requires relocation and those types of situations, the offer should be made to the worker. And if the worker does decline that position because the relocation would be difficult and take them away from their family and their contacts, well, we're dealing with a different situation there. And we would ask the employer to try to find suitable work that was in the position that they were in before, that was in the location that they were in before. But I think that a lot of times when things look like it's too far, they wouldn't do it, it just isn't going to happen, that the offer should always still be made, and it should be well documented, the conversations. And also with that duty to cooperate, when you're contacting that person the soonest practicable, you're including that worker in conversations about what type of work they can do, what types of positions. The worker goes to work every single day, so they're aware of all the positions that are there. The supervisor is in contact with the worker and probably knows a lot about their skills and abilities that may be outside of that particular job. This is why we encourage the communication and why that duty to cooperate is there. So there can be conversations, there can be information that's passed back and forth to see if they can find the most suitable position that is in that particular place. But at the same time, if there is relocation available, you make that offer and you document that the offer was made, but the worker may not necessarily be required to take a position that is in a different location.
Thank you, Teresa. And I think this also speaks to having great return to work processes that provides this context within that documentation, right? What does your program look like? What does it include for temporary accommodation and relocation being part of that, right? So potentially. The next question over to you, Ali. How does duty to cooperate and accommodation work with collective agreements?
Yeah, absolutely. So the collective agreement may provide some return to work obligations to the employer that may differ from WorkSafe's duty to maintain employment. And section 154 specifically says that the provision that provides the most favorable return to work options will prevail as long as seniority is not a factor. So if the collective agreement, which most often they do have different applications that include seniority entitlements, then that may prevail. But if that's not an issue, then whatever is more favorable for the worker. So as you can see here, when it comes to return to work options, WorkSafe may have a different opinion as to what is more suitable than the worker themselves. So I think that what we can expect is seeing workers be presented with these offers and comment on what they think is most appropriate for them. But at the end of the day, we got to remember that the WorkSafe claim is there to accommodate the injury limitations and restrictions, not the worker's non-compensable preferences. So I think the emphasis is really going to be on what is the injury, what are the limitations and restrictions, and which one of those two job offers kind of complies with those, not just what the worker prefers.
Okay, thank you. Next question really looks at a layoff circumstances, and Teresa, if you maybe lead on this, and if Ali have anything to add, would be welcome. So what happens when an employee is on a WorkSafe BC claim and a permanent layoff happens, which affects the employee? And this could be in a unionized environment with over 10 employees. And then, of course, the layoff happens, which impacts the injured worker. So the injured worker, who if not would be injured, would be laid off. How does that play into the legislation? Teresa, could you maybe answer that, and or Ali, if you have anything to add on that?
Sure, and I will start by quoting LA by saying it depends, and that's what a lot of what we find with this duty to maintain. There are employment situations where layoffs are a common thing. And if you are, you work with the job, you may work for a certain amount of months, you may work on a particular contract, and you may be laid off. If that employer tends to take you back every time more work comes available, or every time there's a different contract, that can trigger the duty to maintain employment. So it's not necessarily that you have worked there for 12 continuous months, but if you have stayed with that employer over the course of years and they always call you back, even though there were layoffs, there may be a duty to maintain employment there. So it could indeed trigger it. Also with layoffs, if it is something that was going to happen, this is what has happened, then you don't have that duty to keep that person attached necessarily, because there was going to be a layoff and that was something that was there. So there is still a duty to cooperate. There is still that duty to communicate up into the time of the layoff. There should still be conversations that are documented that are happening between the employer and the worker. And if it is a situation where they're continuously calling the person back after layoffs have happened to bring them back when they can, then that conversation also needs to happen, that when there is more work, we will revisit this duty to maintain employment.
Something else, that I can add to that is, even pre-bill changes, employers often have difficulties accommodating the employee and then continuing through that process when the employment relationship is not working out because of non-WorkSafe related reasons. So I think when it comes to this question of, can I terminate an employee during the course of their WorkSafe claim, I think it's really important to be careful, because the employee may be disabled at that time and you may be terminating a disabled worker. But when it comes to duty to maintain employment, is not absolute. Employers are not just required to maintain that worker employed regardless of the circumstances. WorkSafe is really going to be asking the employer, can you establish that the termination was done for non-injury related reasons? And they may still meet that bar. So, but you gotta be careful, because if your decision to terminate is tainted even in a small way because of the injury, then you may get yourself in hot water. But that's the determining question. Why are you terminating the employee? And is the reason connected to the injury? Usually if the answer is yes, you're in dangerous territory.
Okay.
Yes, and also I think Amanda brought up that you want to look at your HR policies and you want to make sure that you're documenting, because most of you already have those policies. So if this person has had behavioral issues, as Ali was stating, there should be a paper trail there. There should be some comments to the worker. There should have been some communication. There should be some recording of that, so that when you're in that position that you need to terminate that person and it was right after their injury. Sometimes the injury, if you don't wear your protective gear, the next time you will be laid off, and they didn't wear their protective gear and got injured. So maybe it was a direct reflection over what has happened, but you need to have that documentation so that you can prove to WorkSafe BC that we've had communications and they are not being terminated because they were injured. They're being terminated because they didn't wear their protective gear, because there were behavior issues, because there were other things going on.
Yeah, same with attendance issues and stuff. Employers often bring up those questions when somebody is hurt, and unfortunately, it really does come down. Our advice is always going to be to try not to terminate a worker, especially if they're on claim, as Ali touched on. It's a gray area, and it doesn't always go the way you think. But I think you're in a much better position if those issues, especially if they were pre-injury. It's hard to say after the injury, like, oh, now it's an issue that the board comes back and they want to say, well, what was going on before this where you tried to address this? So having that documentation of things like write-ups and disciplinary actions or attendance issues or whatever the case may be, or layoffs due to operational requirements and the history there, having documentation of all those things is never a bad thing. And it's much better to have documentation of it when you need it than to need it and not have it.
So once again, documentation, ensuring your programs are clear, policy, processes, and that you can demonstrate that, right, in your program and all the way along. Another question coming, and maybe back to you, Ali, adding more context on collective agreements. Can you outline exactly how a unionized collective agreement may impact an employer's responsibility to maintain employment?
Yeah, a collective agreement may provide even greater responsibilities to an employer to have that worker back at work. And, when it comes to exactly, it's really, what is the wording of the collective agreement? What are their obligations to get that worker to return to work? And when there are competing situations between WorkSafe's determination of what is the duty to maintain employment and the collective agreement, if a worker is not disputing the collective's agreement offer and the employer is willing to comply with that, there may not be a dispute. But to answer your question, it's determined on what does the collective agreement say and what are WorkSafe's requirements. And sometimes you will comply with both, especially if the collective agreement also requires some type of accommodation. It may not be that different from WorkSafe's requirement of what the accommodation requirements are. So I think it's about what are the workers' limitations and restrictions, and how does the collective agreement and WorkSafe's requirement comply to get that worker back at work. So they may not always be competing, but if they are and seniority is not at play, then it's really what is more appropriate for the worker in the circumstances.
Okay,
I
thank you.
agree. I just wanted to add on, and she just kind of quoted it on the end, Ali, that's really an important portion and what we get asked frequently here. So I just wanted to kind of piggyback on that, is that the return to work obligations in the Act do not override seniority. So seniority-based terms in the collective agreement policy are not affected by the duty to cooperate and maintain employment. So seniority is the area where it is not affected in return to work. But everything else, like Ali was saying, the most favorable outcome, the most favorable policy in getting a person back to work is the ones in which we would be applying.
Okay, thank you. And thank you for reinforcing that clarity for our viewers here today. The next question, and maybe we'll start with Teresa and Ali, and if Amanda, if you have anything to add, would appreciate that. Really speaks to the number of employees and how that may fluctuate at different times of the year. So the number of employees at some plants may vary throughout the year, and you may have one of those many plants having a certain amount of workers, like in the winter, it may be sharing team members. There are only 6 employees at one time, but over the summer, it may raise to 25. So within that, since the duty to maintain employment only applies to employers that regularly employ 20 or more workers, how would this apply to our business where the number of workers change or fluctuate throughout the year? Can you speak to the interpretation of the legislation, Teresa, and then Ali?
Yeah, I mean, that's a very good question. And I've always heard the questions around the 12 months, but not so many around that that additional point of having the workers there. So my first questions would be, how often do you typically have 20 employees? And it's not just in the plant, we're talking about your entire employment. So everyone who works in the offices, everything, what is your average amount of workers? And is that 20? And is it the majority of time consistently 20? Because if it is 20 or more, the majority of times you are going to follow with that duty to maintain employment. Now, if you happen to dip below during other points in time with the within the 6 where you have 6 or where you have less than 20, we would be looking at the averages. What do you typically have this? And if you ever trigger that duty to maintain employment, it may be something that we're going to apply to you as we may feel that you tend to be in that amount the majority of the time. My best practices there. The best practices is to follow this. The Bill 41 came as a legal duty to things that we had already been discussing, things in return to work, keeping the employer connected, looking for suitable work, things that were already outlined also in the Human Rights Act. So the best practices are to try to keep that person connected, to try to maintain employment, to try to find suitable work, especially if you are a company that does tend to cross over the 20 and meet the duty to maintain employment. It's just the best practices that you keep that going the entire time.
Okay.
I would add to that, most employers have fluctuation in how many employees are actively working at that time. I think it's important to ask, if some employees are not working, why is the reason for that? Is it seasonal work? Are they on a leave of absence? What are their reasons for the fluctuations? And at the end of the day, WorkSafe will consider the industry. What is the industry and what is the norm in that industry? Is it to have seasonal workers or not? But they will also rely on your Canada Revenue Agency records to see, what do your payroll say about who's actively working for what month to what, was there a leave? Is there a record of employment that can confirm if somebody was dismissed or if somebody's on a leave of absence, or what are the reasons? So I think it's very fact dependent for each particular employer, but their industry is considered into answering that question. And, at the end of the day, it comes down to regularly employed. And what does that mean? I think it varies between employers based on the nature of the work that they do, the type of business that it is, and how long that person has been employed, to see if they can prove sort of a pattern of employment throughout a longer period, which is going to be harder if it's a smaller, newer employer.
Well, thank you. Thank you, Ellie. Moving on to the next question, and Amanda, getting your perspective on this. In regards to how early you could start conversation, depending on the type of injury, but also, whether or not the individual or worker is capable of mentally processing return to work based on that. Can you comment on when should those conversations happen based on that type of scenario?
Yeah.
How early can you begin those conversations, knowing that there may be some other considerations that sometimes it's too early, right? How do you-
And you know what, those situations are so unique. This is another one where, it's really going to depend on the circumstances of that case. I think initially you always want to contact an injured worker and make that initial communication as soon as possible after an injury. Hi, how are you? Are you okay? What happened? Is there anything we can help you with? And that's irregardless of if there's a mental health component going on. Now, that being said, if you're fully aware, maybe you're the supervisor that is, part of the complaint or part of that, you're going to have to use your best judgment. Maybe you're not the best person to reach out. Maybe there's somebody else on the team that can make that communication attempt. Definitely, if there's a mental health component or somebody's in a fragile state, you're not going to be calling that person every day. Like, we need to keep things reasonable, right? So you want to keep communication open. If they're open and welcoming to that communication, then definitely keep it going. If they're not, or if it's doing more harm than good, then it's probably better to take a step back, maybe reach out to the case manager, somebody else involved in the claim, and look for some direction there. There are circumstances where there's, significant mental health component, and you don't always know what's going on with somebody, right? So there might be a pre-existing situation, PTSD, something like that going on. Last thing you want to do is trigger it. So I think you just have to be respectful, be aware of the circumstances, and really take your cues from the feedback you're getting. If you find it's creating more conflict and you're upsetting the worker more than you feel like you're assisting them, then that's probably the clue that communication may be doing more harm than good. And that actually is in the new policy. So, I don't think any of us talked about that, but communication is required, except for where it may prolong the injury or recovery, right? And that really applies in those mental health situations. If it's a bullying and harassment claim or something, calling that worker every day, hi, how are you? Are you coming back to work? Obviously not a good thing. So I think you really have to use your judgment. It's going to be case specific, but I would always encourage an employer to try initially to connect with a worker and then base your future communications off how that conversation went.
Thank you, Amanda. Allie, anything further to add, especially around mental health related claims?
Yeah, I would say that, it's very common for employees who, suffered a psychological injury due to traumatic workplace stressors. And I think that when an employer is in doubt about when is the appropriate time to contact the worker, if mental health is a concern, including, like Amanda said, aggravating or worsening the condition, I think it's very important to log that with the case manager. Because when WorkSafe is trying to make a determination on duty to cooperate or duty to maintain employment, you can go back to those log messages with the case manager that explain your reasons for perhaps delaying the contact with the worker. And so that may not be held against you, right? You may be seen to be acting in good faith and in the interest of the worker in those particular circumstances. So I would say that if you're faced with these difficult situations where a psychological condition may be involved and you're intentionally delaying the process, tell WorkSafe that's why there is delay and those are the concerns that you have. And at the beginning of a psychological injury claim, there's also quite an extensive time where WorkSafe is investigating what gave rise to the psychological condition and what were the events. So you're not expected to contact the worker the next day and say, when can you come back to work? Both parties may still be investigating what happened and what led to the employee's leave and the psychological decline. And you can make WorkSafe aware of that. You can say, I'm not sure if it's appropriate for these employees to come back to work because this job is working with the person that led to their psychological injury claim. So we have to figure that out as well. So I would say that keep a detailed log with the case manager. Something that's important to know is that usually phone call conversations are logged by WorkSafe, and that can be used in evidence later on, whether you appeal a finding that you weren't cooperating or not. So when in doubt, I would say make sure that the information is logged with WorkSafe.
Thank you.
I was just going to add on that quickly
Mhm.
too, Lisa, that another thing to consider is for a worker with a mental health claim or something like PTSD, telephone communication may be stressful. So it's important to consider other means of communication too. During that first conversation, you may want to say, is it okay if I give you a call next week and check in? Or would you prefer that we communicate by email because it gives them a chance to read that information, digest it, take some time and respond back to you. So I think it's important, especially in this day and age, to consider that it's not just telephone conversation. You can make that communication and get those updates by other means.
Excellent. And Teresa, I know you.
Yeah, thank you. Just to add, I just wanted to just restate that with Bill 41, there is no exception for mental health. So the duty to cooperate and the duty to maintain employment does extend to mental health claims. So you should be still contacting the person at the first moment practicable. And they should be also reaching out at the first. This is just not a duty for the employers. It's not about just you contacting them. They should also be reaching out as well. And as Amanda said, you can ask them their preferred means of communication if there is a mental health injury there, or you can your first call doesn't have to be when you're coming back to work. Hey, just when, what do you think it does that it can be, hey, how are you? We see that you filed, please keep us updated. We're gonna, it doesn't have to be that first call doesn't have to be a drilling into suitable work. You want to maintain connection, and maintaining connection and contacting at the first moment practicable is, hey, how are you? It isn't necessarily, what do you think you can do? We'd like to have you back at work now. No, we want to be treating that person as an extension. We work with them, they're our colleague. We want to extend that care. We want to extend that concern. And I also like to state, like with the initial question, when you're talking about contacting early in the early review of the claims, when every employer has an employer report and you have access to your employer report, on that employer report, you can see the job titles of the people who are injured at your job. That is so crucial when you're looking at suitable work, because if you can see who's injured and what types of suitable work would be best for that type of person. You can also see what types of injuries you're having most frequently. So that also gives you an idea of the type of suitable work that you can already have prepared. These are things that you can do far in advance. So when those conversations come up, whether the person has mental health issues or injury, or whether the person has trauma, injury, you already can be prepared with, what? Typically, this is the type of suitable work we offer. So you have things that you can bring into the conversation when it's time to talk about it. And then you can ask that person what they think as well. But remember, this is an ongoing conversation, ongoing communication. And it's not all about always initially about, let's just get you back. Let's just have some conversations. Let's just talk about this. Let's just see where we are. You have a doctor's appointment next week. I'd love to hear about it if you'd like to tell me about it. That's definitely not required, but I just want to know that you're okay. You can have those types of conversations.
Yeah, and
all
I
those
think,
kinds of expectations, right? Having a return to work processes and policies that everybody knows about what will happen
Yes.
when it does happen, right? Otherwise, if it's new, then you have that uncertainty, right? So it's critical. Sorry, Amanda, do you have, somebody?
yeah, I think, what I wanted to add also is that employers are a party to the claim. So even though initially they may not have access to all of the medical records that, may be available on the claim, they may get access to those if they end up appealing a decision. But if not, you're still a party to the claim. So you will see what WorkSafe is doing with respect to healthcare benefits that are being provided, wage loss benefits that are being provided, and also if there's limitations and restrictions that are being accepted on the claim, or if the worker is being sent for an assessment. If that information is put in a decision and you're a copy to it, that may give you further insight as to, where the claim is at and what is the worker's current, medical standing. But, like Teresa said, employers cannot demand of an employee to immediately disclose what is the diagnosis and, what is the treatment, and too much medical information. You can definitely ask an open-ended question where that information may be volunteered, but you don't have a legal right to receive all of those details. But with that being said, you're still a party to the claim, so that information may be shared with you. What I often see with board decisions is that WorkSafe may say, we are investigating this condition, you are currently receiving counseling and you're receiving psychiatric treatment. So even though the worker didn't disclose to you, you may receive that information in some other way.
Once again, it's a collaborative effort. Everyone has roles to play for a safe return, and that's really what this is about. One question going back to seasonal employment. So Teresa, are employers obliged to bring a worker back when it's a seasonal circumstance? If an employer does not have light duties suitable, or seasonal businesses is running low in production and unable to provide work to the employee, just based on that environment, what is your perspective on that?
Our perspective on that is that you still do maintain a duty to cooperate. You still should be having conversations with that worker. And that's probably something I'm going to say with every single answer that I answer, is that you should be still having conversations. However, with seasonal employees and temporary workers, that is the nature of a lot of different businesses. So the duties are a little different there. So if you know that your season goes from January to May, that, May there wasn't going to be any more work anyway, that duty may stop, especially if that person only worked with you during that specific time frame. However, there are people who tend to work within an industry. They tend to work in a planting industry, a tree industry, so they may get hired repeatedly, back to back to back to back, year on. So you may have a duty to maintain employment for that person. That doesn't mean that during the off season you have to try to scrape up a job. What that means is when a work is available again, you may be required to maintain employment and contact that person and try to find them work. So if it is a seasonal employment, if it is temporary employment, it definitely depends. If it was just someone who just came in, they're just going to work this one season, they've worked for you for 3 months, they're injured, you don't have a duty to maintain employment, but you do have a duty to cooperate. You do have a duty to call to offer suitable work if it's available. You still have that duty. So I hope that's clear.
Yeah, no exceptions. That's what you're saying.
No exceptions on the duty to cooperate, but with the duty to maintain employment, if they haven't worked this continuous 12 months and they're not on that repetitive role where they keep coming back, and you keep seeing them, then you don't have that.
Perfect. Thank you. Another question, I'd like all your perspective, or each of your perspectives on this, is really speaks to employers that have difficulty with the doctors and specialists refusing to complete medical assessments, because quite often they're reliant on what types of modified work they're able to do. Do you have any advice for this? And I'd like each of your perspectives on this, because I've heard this question, over the years many times, and I'm sure we all have. So, Allie, your thoughts maybe first.
Yeah, absolutely. We have the WorkSafe bubble, but we also have the non-WorkSafe bubble, when employers also have the right to know what is the potential length of the leave, what is the nature of the leave and, when could the employee come back possibly, right? I think as an employer, they also have responsibilities in the workforce to replace that position if it's going to be a leave that's more permanent. So the employee may have obligations to share some of this information outside, especially if they're also dealing with a condition that is not related to the injury, but a pre-existing condition. As you all know, a lot of the times workers re-injure themselves with a pre-existing condition. So then we have two things at play here, the work-safe injury and also what preceded that. But, something that I do tell employers is that case managers do often request clinical opinions from board advisors. And even though employers, don't have the right to, require WorkSafe to seek this information, you can always speak to the case manager about some of the concerns that you're having. So for example, I've been speaking to this worker about what duties they may do. They say, we don't know. Do you have any indication of what are their limitations and restrictions? And they may choose to seek a board clinical opinion on that issue. And the board heavily relies on these opinions when they're trying to determine medical questions that they may not have the expertise on. And, this is something that you can speak to with your case manager. But this is an issue that we see often with doctors who are not willing to, update the employer on their medical standing. Something that I also see is employers offering to have a medical practitioner assess that worker. So they can say, we have this practitioner that's willing to speak with you. You can, just voluntarily go to this practitioner if yours is not willing to update us, and that's something that they can voluntarily agree to, or you can find your own. But I think, this goes again to the duty to cooperate and maintain communication. Is if one doctor is not available, maybe WorkSafe can provide you with some information through a clinical advisor that you may not have otherwise. So this is not something that you have a legal right, but this is something that I see case managers do all the time.
Okay, excellent. Amanda, I mean, I know you deal with this likely a lot in your support to employers.
We do. And, right now we do have a medical system under stress. So you are seeing sometimes doctors don't have time. If it's a hospital, not going to happen. They're not filling out forms. So some things around this, some options. One, look at other treatment providers. Maybe the doctor or the walk-in clinic's too busy to complete the forms, but maybe the worker is attending physiotherapy. A lot of times physiotherapists are more than happy to get on board with return to work planning, providing an opinion, even helping to develop a return to work plan. So I would look outside the box at other treatment providers and options for that. If you're dealing with a compensable injury, the board's receiving a report on their side, a much more detailed medical report at every assessment. Unfortunately, employers don't always get to see the details of that because it can pertain, other information that they're not privy to. But if you call the case manager, if you call the call center and you say, hey, worker saw the doctor yesterday, wasn't able to get a note. Can you tell me what the last medical was on file and what the limitations indicated there were? They are pretty good about saying, even at the call center, hey, yeah, there's a fitness for work here. They were cleared for light duties based on the medical dated, whatever. So they might not give you the details. It depends on who you're speaking to at the board. But a case manager, definitely, you can always reach out to them and say, hey, we're having some trouble. Can you provide us with some specific limitations and abilities this worker has? And usually that's the quickest workaround to get that information.
Wonderful. Anything to add, Teresa?
Yeah, at WorkSafe BC, we have been reaching out to the medical community about Bill 41 and educating our doctors as much as possible. We hear your frustrations loud and clear, and we note them as well. There's different paths that you can take. First, I don't know if most people are aware of standard physio, and it's actually a quicker workaround. If you have a claim, whether it's pending, whether it's accepted, anything, you get one physio visit. You get one physio visit that can list out those functional abilities so that we can find suitable work for you. So each person, regardless of whether we accept their claim or not, has the ability to see a physiotherapist. People still have the right to see their doctor. But doctors aren't necessarily going to see how much they can lift, and they're not going to do a full functional test. So sometimes taking that functional abilities form to their doctor also yields greater information. But that starts the conversation, is that they do have access to physio, at least one visit, regardless of whether we accept their claim or not, that they don't have to pay for. And that will help you to develop suitable work. Another program that we have at WorkSafe BC is called Early Access to Physical Therapy. That program will allow you to see a doctor within a physiotherapist within 72 hours. So if you have a disability management program that is effective and robust, there are other criteria to meet that. You can enter our Early Access to Physio program, which will allow you 72 hours. You get information within 72 hours, which is really helpful when you're trying to find someone suitable work. Also, going back to that employer report that you have, you can see who is injured and you can see what your most prevalent injuries are. When you know that most people are injuring their back, or most people are injuring their arm, or most people are injuring their leg, gives you the opportunity to determine what types of suitable work are available at your place of employment and how you can support your workers. Regardless of whether they want to see their doctor or the doctor says you get 10 days off or 2 weeks off, regardless of whether that's happening, you have a duty to cooperate. There has to be communication between the worker and the employer regarding what types of suitable work is available. Offer that physiotherapy, make a suitable work offer, document it on your claim. The worker has a duty to not refuse work that is suitable. They cannot just refuse something that is suitable, that they can do. They have that duty. It's under the duty to cooperate. And if they are refusing it, then their benefits can be interrupted by WorkSafe BC.
Lisa, if I can just add to that real quick too, I was going to say that a lot of employers feel they need to wait for medical to make that offer. So Teresa just reminded me, make that offer right away. We
Yes.
encourage our employers, as soon as an injury is reported at first aid, this is before they even go to seek medical treatment. I mean, obviously not if it's a super serious injury and it's an emergency, but somebody cuts their left hand and they come and report it to first aid. There's nothing preventing you at that time and moment from saying, look, you have a cut to your third finger. We have duties that require no use of that hand. So you can kind of play it safer than sorry, offer them the very accommodating modified or suitable work to begin with. And then, they're going to go out, they're going to get treatment, they're going to see their doctor, see their physiotherapist, and hopefully provide you with a lot more detail and limitations. And at that point, you can sit down with them and figure out, okay, you can go back to your regular duties, but we're going to have to remove this and get into that more complex return to work planning. But I think it's important to remind employers that you can offer modified work as soon as an injury is reported to you. So you can base that off common sense restrictions.
So that's wonderful. And really thank you all for that valuable insight, because it can become a real perceived challenge from those at the other end at times, or employers that they're facing this challenge. So we are approaching the hour here very closely. Thank you all, Teresa, Chris, Teresa and Amanda, as well as Ali, for joining us today. Really, the information shared adds clarity, makes it easier for our members to the impacts and changes facing all of us. We will share any questions left unanswered today with our guests and post your responses along with the recording and resources from today's webinar. Education helps us prepare to meet these new requirements. So here at the Alliance, we'll be working to provide the most current and up-to-date information and resources to help keep your programs current. If you find it valuable, we'll also be considering hosting more sessions around this to share more case studies and best practices on return to work and workplace accommodations. Please share your thoughts in the chat or in the follow-up survey that we circulate. And if you have more questions, reach out to our team here at the Alliance. I mean, that's why we're here. We're here to help you. And now some few final announcements before we close. Our Make It Safe is expanding with 4 conferences this year, and the first 2 are now open for registration. Join us in Victoria on March 1st for Make It Safe Vancouver Island, and in Kelowna, April 18th at Make It Safe Okanagan. Space is limited, so please pick your tickets up early here at makeitsafe.ca. We're now also accepting your nominations for the Safety Excellence Award at the Safety Pinnacle Gala in June, and we'll present these prestigious awards and hope to recognize you among the 2024 recipients. Learn more and nominate a deserving leader champion, or your team at safetyalliancebc.ca/gala. Our next webinar is February 27th. We'll feature guests from SDP Compliance, EHS, and their partner specialty technical consultations for more insight into the regulatory trends and updates here in BC, across Canada, and beyond. And to help you get your people trained, check out our full lineup of online training and instructor-led classes, virtual or in person. Visit us online at any time for help or to access our webinars and resources. Watch for an email tomorrow with a link to the recording of today's session, and of course, a survey link to share your feedback and topic ideas, because we do take that feedback and make differences into our future planning. As you leave, please share your thoughts in this very quick survey. Thank you all, and take care.